Magandang hapon. Thank you so much, Mr. Abdallah, Dr. Abdallah, for taking time to speak with us today. It is such a great pleasure, of course, and we very much appreciate this opportunity to gain insights from the ICC's perspective with regards to these developments that have been happening.
You are very much welcome, and welcome at the ICC headquarters here in The Hague.
Thank you. So let's begin, Dr. Abdallah. For our first question, former President Duterte's camp claims he was illegally arrested in the Philippines and brought to the ICC in the Netherlands, which they argue has no jurisdiction over the Philippines since we have already withdrawn from the Rome Statute. What is the ICC's response to this?
I think that there are two different questions here. One is the issue of the arrests, and if there are requests regarding the lawfulness of the arrest itself, it can be presented to the judges who will decide on it. Second question is the question of jurisdiction of the ICC over crimes allegedly committed in Philippines before its withdrawal from the Rome Statute. And that's something on which the ICC has already been clear, whether it's in regard to Philippines or Burundi, which is another state that also withdrew from the ICC Rome Statute. So the court's jurisprudence has already indicated that the ICC retains jurisdiction even after the withdrawal of a state, but only for the crimes that are allegedly were committed during the period when the state was a state party to the ICC Rome Statute. So for the Philippines, I think from 2011 or 2012 until 2019, this is the period in which Philippines was a state party. So crimes allegedly committed during this period in Philippines were under the ICC jurisdiction and remain under the ICC jurisdiction. The withdrawal does not affect these obligations and this jurisdiction of the ICC. It only affects the future. So after the withdrawal become effective, if new crimes are committed, then they will not fall under the ICC jurisdiction. But the jurisdiction was already there during the period when the Philippines were a state party, or Burundi, which is the other example, and then the exercise of this jurisdiction can be after the withdrawal. There is no problem in that. But the application of the law on international treaties means that this jurisdiction was already existing, and thus the ICC can retain it.
After the arrest of the former President Duterte, was it necessary for the Interpol and the Philippine authorities to bring Duterte first to a local court in the Philippines before bringing him here in The Hague?
Well, this is a matter that depends on each state internal laws. So in general theory, there is a process when a person is arrested in a certain country before he is surrendered to the ICC. But these processes can be very different from one state to another, and I'm no expert in the Philippines laws. So this is a matter of internal law on which I cannot actually decide. As I mentioned, the legal process before surrendering a suspect to the ICC can vary from one country to another.
But as far as you are concerned, there is nothing illegal in terms of his arrest.
I can simply say if there is any challenge to the lawfulness and legality of the arrest, it can be submitted to the judges, and then judges will decide on that. I will not speculate on a possible request and what might be the outcome for this request.
It is up to the judges
to
decide on it. What is the ICC's reaction to the Interpol's implementation of the arrest warrant against Duterte? And how would you describe the process of serving the diffusion notice by the Interpol and the Philippine government?
I think that the important thing to remember is the idea that there are international accountability mechanisms in order to ensure that when there is an arrest warrant, that the states cooperate with the court. Interpol is one of the channels to help with these mechanisms. And as we have indicated before, we're also grateful to the Philippines' commitment to this international accountability mechanism because it's important. It's important to clarify what is the reality of what happened. It's important for the victims to see that justice is working for them. It's important also even for the suspects to clarify whether they are really guilty or not. So the process has to take place in order to ensure that truth is revealed, and then if there is a responsibility, then the persons are held accountable.
Did the ICC or did the Philippine government coordinate with the ICC before the former president's arrest?
I think that there is an arrest warrant that was issued by the ICC judges, and of course, naturally, when an arrest warrant is delivered, then it is communicated to the states on the territories of which the suspect might be present. So it's totally normal that after an arrest warrant is delivered, we contact the states to ensure the surrender of the arrest and surrender of the suspect.
Because I understand there was a statement before by the former, there was a statement before by President Bongbong Marcos saying that we will not cooperate with the ICC since it has no longer jurisdiction to the Philippines. But right now, the former president was surrendered to the ICC. That's why the question of whether the Philippine government coordinated with the ICC prior to the arrest of the former president.
Well, as I was mentioning, we need to distinguish the issue of the jurisdiction from before and after the withdrawal of the Philippines. Crimes that allegedly were committed before the withdrawal of the Philippines from the ICC Rome Statute remains under ICC jurisdiction. So the ICC has jurisdiction over these past alleged crimes, but there is no jurisdiction currently over Philippines for if crimes would be committed after this withdrawal. So the issue of jurisdiction is different from the issue of the cooperation. Now, the issue of the cooperation, as I said, it was for the Philippines authorities to cooperate with the international accountability mechanisms and with the ICC, and we are really grateful that this was done to make the truth clear for everyone and to see the process of justice working. As for the cooperation with the Philippines, as I mentioned, after an ICC pretrial chamber delivers an arrest warrant, it has to be communicated to the different states in order to ensure the arrest and surrender of a suspect. So it's a natural process.
All right. Some view Duterte's case as a gift to the ICC, noting that the court's conviction record primarily involves African warlords. They suggest that this case is a significant boost for the ICC. How do you respond to such claims?
Well, first, I think all cases before the ICC are about very serious crimes, about mass crimes. By definition, the jurisdiction of the ICC is about war crimes, crimes against humanity, and genocide, and in certain cases, the crime of aggression. These are very serious and very grave crimes. So all cases before the ICC are important. And for us, it's very important to always remember that why we are doing all of this is because victims have suffered and they deserve to know the truth. And accountability has to be there in order to ensure for the future, a better future for everyone. Now, that being said, we need to understand that historically, most of the cases before the ICC were related to conflicts in Africa. But that's because the African states themselves had asked the ICC to open an investigation about it, or because the Security Council of the United Nations also asked the ICC to open an investigation in relation to Libya and Sudan, also in Africa. But that was a certain amount of years ago. Since then, the ICC has opened other investigations, whether in regard to Ukraine, to Afghanistan, to Philippines, to Palestine, and in other places. So it's no longer only about a certain region. The ICC jurisdiction is over 125 states that are parties to the ICC Rome Statute, over their territories, if anyone is committing crimes on their territories, even from non-state parties, or if crimes are committed by their citizens anywhere in the world. That's the parameters of the ICC jurisdiction. And these parameters have to be applied consistently over all these places. And that's what we are trying to do. So for us, we are working in a legal framework according to the Rome Statute that was adopted by the states. The states created this institution, and the work of the court is actually to implement this legal framework. And while there were historical reasons why we started with a certain number of investigations, but currently we have investigation over 4 different continents, and I think all of the cases that are before the ICC are very serious, very important, and we need more cooperation from all different states Also because there is a certain number of arrest warrants that have not yet been implemented, and that is important also that the states cooperate to arrest and surrender these other suspects.
How do you view this case in particular, considering that this is the first ever Asian leader to be surrendered and to be facing a case at the ICC?
As I mentioned, we do not look at the situations or at the crimes depending on where they were committed in this or that continent. We have investigations in 4 different continents, and we have already issued arrest warrants in a number of situations, not only related to Africa, but also related to Asia and to Ukraine and so on. So we think that it's important that we keep working in this direction, and we hope that there will be more cooperation from the states to implement these other arrest warrants as well.
The ICC is recognized as a court of last resort, intervening only when national judicial systems are unwilling or even unable to genuinely investigate and prosecute individuals for the gravest international crimes. By taking on Duterte's case, some may interpret this as a sign that the ICC lacks confidence in the Philippine government's ability or willingness to handle such cases. How do you respond to these observations?
Well, we need to explain the principle of complementarity before the ICC. As you mentioned, the ICC is a court of a last resort. What does that mean? That means that the primary responsibility is with the national tribunals. But if they are unwilling or unable, or if they haven't opened cases, then the ICC can intervene because there is no other venue for the victims. Now, that means that if there is no case against the same individual for the same alleged criminal conduct, then the ICC can go ahead with the case. The principle of complementarity is not a general judgment over the ability of the system. It's a specific judgment over this specific case. So that means that if there were, for example, national proceedings against the same suspect for the same alleged conducts, then his or her defense team, or even the state that is concerned, can raise a challenge to the admissibility of this case before the ICC and say that the ICC should stop the case because there is already a case that has started before the national tribunals, and it's substantially the same case, and that the national tribunals are genuine about it. They have to demonstrate that. In these conditions, then the ICC would stop the case before it. But if there are no cases, or if the case is about another suspect, or if the case is about different alleged criminal conducts by the same suspect, then substantially it's not the same case. And that means that the principle of complementarity would not be applicable on this specific case. So we are not making a general statement about the Filipinos tribunals. We are only saying that for this specific case, at this moment, we are not seeing that there is a legal process in the Philippines about this specific individual and for this specific allegations. If they were, then his defense team or the Philippines can actually ask the court to stop this case if they can prove that there are genuine proceedings against the same person for substantially the same alleged conducts.
All right. With regards to the interim release, let me just go back a bit on the legality of his arrest. Will the manner of Duterte's arrest, which his camp claims was illegal and tantamount to kidnapping, have any impact on the case he is facing, especially if he requests for an interim release?
Well, I cannot speculate on that. If there will be a request either about the lawfulness of the arrest or about an interim release, it will be for the judges to decide on it. And I don't know if the defense will do it, and I cannot speculate on what the judges will actually decide.
Under the ICC, interim release is an option for suspects, right? What are the common grounds for granting such a release? Have there been any ICC suspects in the past who were granted interim release? Were they ultimately convicted or acquitted?
Well, we need to understand that the principle is to respect the presumption of innocence. So, as a matter of principle, we consider that every suspect is innocent unless and until there is a trial after which he or she are convicted beyond any reasonable doubt. And that presumption of innocence means that the principle should be the freedom of the suspects and not their detention. When the judges issue an arrest warrant, that means that they believe that the arrest of this specific individual is necessary either because he or she are still committing crimes, or because he or she would not appear before the court and cooperate with it if the court issued a summons to appear and not an arrest warrant, or because they believe that maybe without arresting this individual, they may be creating obstacles or threats to the proceedings, to the investigation, or to the witnesses. So they have to justify that. An interim release can be requested if there is a possibility to put in place measures and conditions to ensure that if a person is released, none of that would happen, and that this person will be brought again before the court if the judges order so. And that means that there is a different set of conditions that needs to be checked. First, in which country this person might want to be released. Does this country accept this release? If the court is ordering certain conditions and measures to be put in place to ensure that he will not be in contact with this or that he will not be threatening the investigation, that he will be brought again before the court when the judges order. Does the country accept these conditions and measures or not, and so on. So as a matter of general principle, there is all these conditions and questions need to be discussed before the judges, and then the judges will decide whether or not to grant an interim interim release with or without conditions, as I mentioned. It has happened in the past that certain persons were granted interim release or conditional release on different situations, sometimes temporarily for specific, sometimes personal conditions, and then back to the detention center. But again, it would be for the judges to decide on that if there would be a request to that effect.
So even personal reasons?
There has been short releases, for example, for private life circumstances for certain individuals in the past. We, as a matter of principle, respect this privacy, so we cannot actually discuss in details what actually happened, but that was very short moment. And again, it's the judges who decide on the interim release as a matter of principle. They decide also on the conditions and the duration of it.
And eventually after that interim release, were they convicted or acquitted?
I don't remember the full details of these different cases, but there is no link between the interim release and the final decision, because the interim release can happen at a pre-trial phase or at a trial phase. It's up to the judges to decide on it and on its conditions and on its duration. And it's not a prejudgment of whether this person will actually be acquitted or not. These are two different and separate questions.
All right. Have there been instances where the pre-trial or the trial chamber considered the actions and behaviors of, or the behavior of the suspect supporters in their decision making? In theory, how significant could this factor be in influencing the outcome of a petition, a certain petition or interim release, for example?
Now, we have to understand that the judges can only decide based on what is presented before them, either by the prosecution or by the victim's lawyers or by the defense lawyers. So they are not taking into account any other elements that are not in the files before them. So this type of actions is showing support to certain suspects, but it's not part of the findings before the judges, so it cannot be taken into account by the judges. But something that has to be also understood is that the judges, of course, do understand the question of ensuring that a person is brought before them. And in certain instances, the question of whether this person can be kind of at large and not return before the ICC. So what kind of networks or capacity he might be able to use in order to hide can also be taken into account for the questions of interim releases and stuff like that. But it's not about the petitions or the demonstrations or stuff like that. This is, I understand, it's supporters showing their support to a certain suspect, but it's not a question that is before the judges. It's not presented to them, so it doesn't have an impact on the proceedings.
How about a certain group actually collected 64 to 65,000 signatures, of course, asking for the former president to be brought back to the Philippines and just face his trial through video link whatsoever. And this, I understand, was submitted as a petition by this particular group here at the ICC. Will there be any implication, or will it actually affect will it even reach the court if it is submitted by a civilian?
No, we need to understand that the judges, as I mentioned, can only decide based on what is presented before them by the parties and participants to the proceedings. So if there is no standing for a certain individual, meaning that they are not representing one of the parties, that they are not representing the victims, they are not admitted in a certain way to the legal proceedings, then they cannot make petitions to the judges.
All right. The possibility of securing interim release is really closely watched by the Philippines. It is closely watched in the Philippines. If ever, the ICC has signed interim release agreements with Belgium and Argentina in the past. Are these the only two options for a suspect seeking interim release? How likely or unlikely is it for a petitioner to be returned home or to their home country instead?
Again, I would not speculate on the potential outcome of a potential request.
All right.
First, we'll see if the defense will present a request for interim release, and then we will have to see what the judges will decide on it. Now, as a matter of principle, the ICC can enter into general agreements for interim release or for other purposes with different states, but can also enter into ad hoc agreements with certain states for specific cases. This will depend on the request and on the willingness of a certain state to accept and to implement the measures and conditions that might be ordered by the judges. So this is something that we prefer not to speculate on. We have to respect the proceedings, the integrity of the proceedings, and to respect that the judges are impartial and they are doing their job in a professional way and based on the legal rules and the evidence that is presented before them.
If in any case an interim release will be granted, what are usually the preconditions and conditions imposed, and how long does an interim release typically last?
Well, again, it's a matter that will have to be decided by the judges. I explained a little bit the general framework of ensuring that a person will reappear before the judges when he or she are ordered to do so, that they will not be putting in danger the proceedings and might and would not be continuing to commit crimes and so on. Now, the technical measures and conditions have to be decided on a case-by-case basis by the judges and have to be accepted by a certain state for it to be ordered by the judges. So I would prefer, as I mentioned, not to speculate, to respect the process and to respect the impartiality of the judges.
Okay, in the history of ICC trials, has there been a case where supporters of an accused have camped outside at the ICC or even the detention facility, as is happening now?
I know that usually every media love this type of questions about the first to happen before the court, and I know also that for every single situation and for every single country, they feel that their case is a bit different from the others. But the reality is, for us, all the situations are very important. They are all about very serious and grave crimes. And we don't look at it in a different way based on this country or that, this profile of the suspect or this. And we have been working for over 20 years. So we have seen many different situations. And I can assure you that, yes, it has happened before that we had demonstrations and different ways of supporters showing their support to the suspects.
You know, supporters of the former President Duterte are known for their very passionate stance. It is also public knowledge that some have resorted to name-calling, issuing threats against those involved in the case, and even spamming the social media pages of the ICC judges. How is the ICC addressing this concern?
I think that the main thing that we need to understand is justice acts in an impartial way, and justice has to act in the time that is necessary for justice. We have to respect the process. It's not about being passionate. It's about being objective and impartial and applying the law and checking the evidence thoroughly and ensuring that the rights of the defense are respected and that the rights of the victims are respected. That's what we are working about. So we understand that there is always a lot of passion in the realm of social media, and we understand that by definition, the persons that are suspected by the ICC, they are suspected of very serious crimes and mass crimes. So by definition, they retain a certain amount of power and they have supporters. But we do not consider that this is that this should be something that would be kind of distracting our focus from what we have to do, which is our core tasks and core responsibility towards the victims and toward the international community, which is to apply the law in an objective and impartial way. And we trust that in the social media there will always be some passionate and heated individuals, and we understand that there is also good people that will be actually trying to show the objective nature of things. And we call on everyone to actually rely on the ICC channels for the correct information and not on rumors, and to understand that rumors might be putting in danger sometimes potential victims or potential witnesses, and sometimes people that have nothing to do. It might be a wrong name or a similar name, and they should avoid that because it's a matter of responsibility. It's putting in danger the lives of individuals with no reason sometimes. So they should trust the justice and trust the impartiality and the objectivity of the work of justice.
We understand that you want to remain focused in your work, but even the spamming of the ICC judges' pages does not alarm you at all.
I think the main and important thing is that for the courts, the judges, the staff that are working here, the ICC prosecutor and his team, the defense teams, and the lawyers that will be representing the victims, we are all focused on only one thing, which is delivering justice in the best conditions for the victims and to ensure that truth is revealed about the guilt or innocence of any person who is accused.
How does the ICC monitor suspects who have been granted interim release?
Well, it depends on the situation, on the measures that might be ordered by the judges. It's a matter of an agreement with the authorities, and of course we do that depending on a case by case.
What are the consequences if a suspect granted interim release goes into hiding and never appears before the chamber again? Has such an incident occurred in the past?
No, it did not. As I mentioned, when we have this type of request for interim release, the first thing is to secure that the authorities where the person might be released are actually committed to ensure the implementation of all the measures ordered by the judges.
But in any case that a person goes into hiding?
It did not happen, so.
All right, so from now until September 23, which is the scheduled confirmation of charges hearing of the former President Duterte. And when former President Rodrigo Duterte faces the pretrial chamber on this particular date, what can the Filipino people and the rest of the world expect to happen in between? And what aspects of the process will be made public, and what will take place behind the scenes?
We need to understand first what is a confirmation of charges hearing. A confirmation of charges hearing is not a trial, and it's not a pre-trial. It doesn't prejudge whether the person might be found guilty or not. It's simply a kind of a filter for the judges to check if a case can go to a trial or should be stopped at the pre-trial level. So first, the judges have heard only from the prosecutor. Prosecutor made the request, and they issued an arrest warrant based on their first review of the evidence presented by the prosecutor. This is a threshold that we call having reasonable grounds to believe that a person has committed a certain crime. Now, before going to a trial, which can be lengthy, which can be costly, which can be tiring for the potential accused person, that can be heavy on the victims and on the witness, before going that, we need to check again whether the prosecutor evidence is strong enough to justify to go to a trial. But this time, in order to check it again, we need to hear what is the defense views on it. Maybe the defense has a different interpretation, or can actually show that this evidence is not correct, or they can be presenting counter evidence and counter testimonies. And we need also to hear from the victims, what do they think about the legal questions that are raised? What are their personal views and observations on this process? And then the judges would check again this evidence against a higher threshold, which is to know whether or not there are substantial grounds to believe that a person has committed these crimes. So we passed from reasonable grounds to substantial grounds. And then if there is a confirmation of the charges and a case is committed to a trial, then new judges will have to check if a person is found guilty beyond any reasonable doubt. But if there is a reasonable doubt, then he will be declared innocent, and there will be an acquittal. So before going to a trial, the judges will have to again check the prosecutor's evidence, check what the defense have to say about it, and check what the participants, so the lawyers representing the victims, will have as observations or personal views. Now, between now and the moment where we will have the confirmation of charges, we need to prepare for this. Meaning, if we are saying that the defense might have something to say about the prosecutor's evidence, that means first that the prosecutor will have to disclose this evidence and transmit it to the defense teams. That's why we have this period between now and September, because the prosecutor will have to give this evidence to the defense in a meaningful way, in an organized way, but also the defense needs to have the time to counter-investigate about who are these witnesses, what kind of documentation is it? Is it reliable? Is it not reliable? Can we present counter evidence, counter testimonies, counter documentation? We need also to organize the participation of the victims. Who are the victims that might be allowed to participate? Because they have to demonstrate that they have a link with the case. Who will be the lawyer representing them? What are the observations of this lawyer? So we put in place all these measures during this period between now and September. In September, there is the confirmation of charges hearing, which usually lasts a couple of days, during which the prosecutor will be presenting certain amount of evidence on which he intends to rely for the purpose of the confirmation of the charges, and in which the defense can actually be presenting counter evidence. And also the lawyers representing the victims will be able to make their observations. In certain cases, there was a limited number of witnesses called for that purpose of the confirmation of charges hearing. In other cases, there was no witnesses. It was all through documentation and written testimonies. And there are, of course, statements by the prosecutor team and by the defense team before the judges. So there are hearings for a couple of days, but not necessarily that there are witnesses. If there would be witnesses, of course, each party will have the right to cross-examine the witnesses called by the other party. There is also possibility for the lawyers presenting the victims to make observations, and then judges will take up to 60 days to decide on whether or not they confirm the charges in total or in part, or if they decline to confirm the charges. If one or more charges are confirmed, then the case can be committed to a trial. If all the charges are declined to be confirmed, are rejected, then the case would stop at the pre-trial stage, so not even going to a trial.
Not even proceeding.
There's a possibility for both parties, so for the accusation and for the defense, if they are not satisfied with the outcome of the confirmation of charges, they can seek a leave to appeal this decision. It's not automatic. It can be granted or not. And then if there is an appeal, then it will be eventually for the appeals chamber to decide whether or not to confirm the decision of the pretrial chamber or not.
And of course, you've already given us an insight or a picture of what is going to happen in the next few months prior or leading to the September 23. But on September 23, particularly, what can we expect to happen? Will the judges make any major decisions that day, such as, like you've mentioned, whether this is going to proceed or this will be dismissed right away?
No, normally what happened, as I mentioned, the confirmation of charges hearing lasts for a couple of days.
Okay.
Normally it starts
Just
with...
not just September 23.
No, normally it's a couple of days, so it might be 23, 24, 25, but it's not a very long hearing. And it normally starts with what we call the preliminary statements. So normally the prosecutor will be announcing what is the big picture that he will be trying to show to the judges. The defense will be doing the same. The lawyers presenting the victims will also be presenting their own observations, the views of the victims on this whole process. And after that, we enter into more details. So the prosecutor will be presenting the judges with more evidence on which he is relying for the purpose of the comprehension of charges. Not all the evidence that the prosecutor would have, because that would be at a trial if we get to a trial. But the prosecutor will give a kind of a sample of the evidence on which he intends to rely, and the defense will be able to discuss this evidence and present its own evidence as well. Normally, most of this hearing is actually public, but it is possible for the judges to order a closed session if there is information that might be sensitive either for a state or for the protection of a witness or a victim, for example.
All right. After the September 23 confirmation of charges hearing, or probably, as you've mentioned, might take a few more days after that, will there be additional hearings?
Normally, there is this kind of the comprehension of charges hearing that lasts a couple of days, and it is possible for the judges to ask the parties to kind of complement their statements in the hearing with written observation. So that is a possibility. And after that, as I mentioned, the judges can take up to 60 days before delivering their decision. It's very rare. I don't remember any additional hearings. Most of the procedure after the confirmation of charges hearing is actually in writing.
So it will take another 60 days after the confirmation of charges
Up
hearing?
to 60 days. It
So-
can be shorter, but the judges have to issue their decisions in a maximum of 60 days after the closure of this process of confirmation of charges hearing, and eventually after the written observation, if there are requests for written observations.
So there is no instance wherein after, for example, after the 3 days of the confirmation of charges hearing, a decision has been made right away?
No, the judges will have to study what has been presented during these 2 or 3 days. Eventually, if there are additional observations in writing, that also have to be examined carefully and thoroughly. And after that, the judges will have to check for each charge if they consider that there is substantial ground to believe that the suspect has committed this specific charge, you know. And they have to study all the charges eventually presented in a certain case and make a decision about each one. So normally it takes more time. The decision is not instantly after the hearing. That's why we have up to 60 days for the judges to issue a decision.
All right. Is a face-to-face meeting between the former President Duterte, who is being accused in this particular case, and the victims or the complainants inside the chamber expected?
We don't have a system of complainants at the ICC. For the ICC, the case is by the prosecutor against a certain suspect. So it's not that a victim has started a case before the court. It's always the prosecutor who have to decide of accusing someone, and then the judges will decide if they will actually be accepting what the prosecutor is saying or not. So the starting point is always the prosecutor presenting a request to the judges to issue a summons to appear or an arrest warrant, because the prosecutor believes that this person has to be held accountable for a certain alleged crime. So there is no complainants. Before the ICC, what we have the parties, so the prosecutor and the defense, and then we have the participants, which are the victims that are allowed to participate. But the participants are not a second prosecutor. They are not there to accuse a suspect. They are there to tell the judges their stories, their observations, their point of view, represented by a lawyer. In most of the cases, we are speaking here about the lawyers being present in the courtroom and not the victims. We have cases where we have 5,000 victims or 10,000 victims. We're not expecting all of them to be present in the courtroom. And we have to make a separation between a victim and a witness.
Yeah.
So a
How do
witness
you-
may or not be a victim. You can have witnesses that are experts on a certain area, witnesses that are insiders that came from a certain organization that may have been accused of committing crimes, and they were like part of it. They themselves knew what this suspect had decided or not. So there are different types of witnesses. Not all witnesses are victims. Actually, most of the witnesses are not victims. And not all the victims are witnesses. Actually, very limited number of victims would be called to be a witness. And normally, most of the victims will be represented by a lawyer. In very few instances, the judges allowed one or two of the victims to come in person and tell their stories. But they are not there to accuse someone. They are there to present their point of view, their observation, and their stories to the judges. The accusation is done by the prosecutor, and the witnesses are called by the parties, either the prosecution or the defense.
But there's still a possibility for some of the witnesses
To be a
actually facing those the person being charged.
Yes, it is a possibility. If a witness is at the same time a victim, this is a possibility. But as I mentioned, for the confirmation of charges hearing purposes, it's not very often that we have witnesses that are called. There have been instances where one or two witnesses were called during the confirmation of charges hearing, not necessarily victims witnesses. They can be experts on something. So it's not the most recurrent thing before the court. For a trial, it's a different matter, because during a trial there is a long period, there is many witnesses that are called, and this type of scenario might happen. But at this moment, we should not be speculating on the outcome of the confirmation of charges hearing. First, this has to happen, and then the judges will decide on whether or not to commit the case to a trial.
Will there be a cross-examination in this stage?
If there are witnesses that are called, then of course every party has the right to cross-examine the witnesses called by another party. But as I said, normally during the confirmation of charges, either no witnesses are called or very limited number of them.
The ICC judges also come from various countries. Do they reside within this building for security reasons, or what strict code of conduct do ICC justices adhere to in order to uphold impartiality and integrity?
Well, first, they don't reside inside this building. This building is a working building, and they have the right also to have their own private life, and we have to respect that also, and to make sure that they are allowed to work in the best conditions. Now, the judges are elected by the Assembly of States Parties, meaning that there is 125 states that have elected a certain individual. And they are elected based on a set of conditions of experience, but also of recognized integrity. They have a history of experience and recognized skills in the field of international law or criminal law, or both. And of course, they have all the statutory guarantees within this system to make sure that they have all the facilities, all the conditions to be able to conduct their work in the most objective and impartial way. And part of the system is also done in a way that we have always checks and balances. So the prosecutor has to present a request to the pretrial chamber. For example, there's a possibility to appeal the decision of the pretrial chamber. There is an appeals chamber composed of 5 different judges than the 3 judges of the pretrial chamber. So the whole system is designed in a way to make sure that the final decision will always be the pure application of the legal rules according to the evidence that is available before the judges.
All right. Thank you so much for enlightening us this afternoon and for all the answers to the questions. It's really we appreciate very much the insights that you've shared with us this afternoon. So once again, maraming salamat. Thank you so much, Dr. Abdallah, for this time, for taking the time to be with us and speaking with us this afternoon.
My pleasure. Thank you.
Thank you. Thank you. It was a long interview. But,
I hope you found it useful.
Yes, very useful. Very, very useful. Thank you so much.
My pleasure.
And thank you for patiently answering all the questions, since it is new to us.
I understand. It's a complicated system that is different from the national system. So it's normal that it takes a bit more time and we have to be available to explain it to the citizens to understand what is a confirmation of charges, why it's different from the national system, what is the principle of complementarity. You know, all the questions that you raise are very valid questions, and I think that the Filipino citizens deserve that we actually try as much as possible to explain it to them and allow them to understand why the court is operating and to trust that the court is working in an impartial and objective way.
I was wondering if I can also ask about the crimes against humanity when the camp of the former president is saying that there are only 43 in total that they submitted, that the prosecution has submitted to the
No.
ICC. How can it become crimes against humanity if it's just 43? We understand that one life is more than enough if it is lost, but 43 is against the thousands that the government is claiming, and for it to warrant crimes against humanity.
Well, we need to understand the legal framework in general, but also we need to look at what actually the prosecutor has requested and what the chamber have decided. The legal framework is that a crime against humanity is can be a murder, can be an other number of criminal conducts, but if they are committed in the context of a widespread or systematic attack against a civilian population according to a certain plan. So if there is a plan that involves a widespread or systematic recurrent attack against civilian population, even one murder may be considered a crime against humanity. Now, before the ICC, there is criteria of gravity that the ICC has also to look at the gravity of the crimes and only take the crimes that are of a certain gravity. If we look at what the prosecutor has requested, first the prosecutor requested more charges, not only the charge of murder, and what the judges have decided for the time being only on the charge of the murder. We'll see if there will be other decisions, but for the time being there is only the charge of murder. But they took the 43 incidents as a sample for the purpose of this arrest warrant to decide if there is a reasonable ground to believe that there has been a widespread or systematic attack against the civilian population, and if there were allegedly murders in that context. They took it as a sample, but that's not all what the prosecutor have actually requested. So we need also to understand that for the purpose of the arrest warrant, the judges took a sample and they said, okay, that would be sufficient for us to issue an arrest warrant. Now, for more details, we will discuss it during the process.
But they can add later on.
Yes, the prosecutor can request. There might be pending issues also to decide on. The defense might be able to submit additional requests during this period. So the judges might be taking other decisions between now and the confirmation of charges.
Until when is ICC receiving the application for participation from witnesses or from victims, perhaps?
Well, witnesses cannot apply to participate. Witnesses are called either by the prosecutor or by the defense.
How about those victims or the families of the victims of
For the victims and their families,
extrajudicial killings?
yes, there is a dedicated section at the ICC called the Victims' Participation and Reparation section that is working on making available on the website and through also intermediaries, through the work with lawyers and associations and so on, to reach out to potential victims, to explain to them their rights to participate if they wish so in the ICC proceedings, to be represented by a lawyer. And we have to highlight that participating in the proceedings is different from requesting reparations. Before the ICC, we do not discuss the issue of reparation unless a person is actually declared guilty after a trial. This is a separate process. What we are speaking now is the possibility for potential victims to participate in the proceedings, meaning to be represented by a lawyer who will be transmitting to the judges their observations, their stories, and their points of view. So this is the participation process.
But you don't have to be a participant for you to be able to claim reparations in the future.
No, this is a separate process. As I mentioned, there is participation during the proceedings. If a person is found guilty, then we open the process of reparations, and then other victims may be willing to seek reparations if they are victims of the crime for which a certain person has been actually declared guilty.
And you have to apply for reparation if you wish to receive one.
It's very early to discuss this in the situation
Okay.
of Philippines. Normally, there is an order by the judges. If a person is found guilty, then there is a discussion about what measures of reparations can be actually accorded. There's a plan for that. There are certain measures. It can be individual reparation. It can be kind of symbolic reparation for everyone or for a community, or it can be a project, for example, building a school or building a health center and stuff like that. So it's a bit different, but the principle that yes, the reparations are reparations for the victims of the crime for which a certain person has been found guilty. And this is very early to discuss in the case of Philippines.
We understand, but how long does it usually take for the whole process to finish or to be completed?
It can vary a lot because it depends on the number of the charges that are eventually at a trial. In certain cases, we had 5, 6. In others, we have 70 charges. So, of course, deciding on that is different. The number of witnesses that will be called might be different from one case to another. The requests that will be submitted by the defense or by the prosecutor can be different. But also, in certain cases, we have much shorter proceedings because at the beginning of a trial, the judges will ask the accused, do you admit your guilt or not? And in certain cases, they do admit the guilt. So there is no need for a long process. It becomes much shorter. So there is no general knowledge of how long a case would last if it goes to a trial, because it depends on the case's circumstances. For now, again, for the Philippines, we are too early to discuss that. We are at a pre-trial stage. We need to first get to the confirmation of charges hearing and see what the judges would decide about the charges.
This, I'm just curious because the former president who is now detained at the ICC detention facility is also running for mayor in his hometown in the Philippines. So that the election is happening this May 2025. The possibility of him being able to return for his campaign and for the elections, how possible is that?
I cannot speculate. If there will be a request for an interim release in the Philippines, it will be for the judges to decide on it.
Will it fall under the personal reasons and considerations?
It will be for the judges to decide.
All right. Thank you so much.